thank you to everybody who is able to join us today. We are going to do a little whistle-stop tour of some key observations on new ongoing condition of registration with the OfS E6. By way of brief introduction to all, we are all principal associates here at Mills and Reeve. Sian, Jones-Davies and I advise on regulatory and public law matters peculiar to higher education, and Sian Jackson advises on employment law in the HE context. The fact that we have both of them speaking today just shows the need for a joined up approach to addressing E6. I will just move a slide on to some housekeeping and say that we will and we are recording this session today, and we will be making it available to you afterwards along with the slides. We are also going to provide a bit of information about how we can assist you in compliance with various aspects of E6, and there'll also be an opportunity to give feedback, which would be brilliant if you can provide that afterwards. If we have time at the end, which hopefully we will, there will be some questions. So if you can put some questions in the Q&A box on your screen, we will see those, but no one else will see who's asked what. So it is anonymous. And if you want it to be anonymous to us, there is another box you can tick so that your question is anonymous as far as we're concerned. And we'll do our best to get to some of those. But without further ado, then I will hand over to my colleague, Sian Jones-Davies.
Thank you very much, Kate, and good morning to everyone. And just let me echo what you said a moment ago, Kate, about this being an area that affects both staff and students. But that said, I'm going to make some general comments now from a student perspective. And I'm going to start with a quick recap of what is in this new condition. And you can see on the slide there references to its scope and also to the provisions which set out the definitions. The scope is, as you will know, very wide. It affects really anything to do with students and harassment and sexual misconduct. On the face of it, that's going to include not just registered students, and it's going to apply across your different cohorts of students. So I think that's going to require universities to think about how different cohorts are going to be impacted, for example, undergraduates, postgraduates, part-time students, apprentices, etc. And in particular, I would encourage you to think about how it may affect your collaborative arrangements with partners both nationally and overseas, including in relation to subcontracting franchise type arrangements and also validation arrangements where perhaps those students, whilst they may be getting one of your awards, won't necessarily be registered with you. So the scope is very wide. We also have a number of definitions set out in the condition. Those definitions are crucial to understanding what the condition requires of registered universities. I think it's interesting that the condition itself is just shy of 2 pages long, but we have 5 pages of definitions, which, as I said, are very important to understand. It's not the easiest condition to navigate, certainly without a clear understanding of those definitions, which, as the slide shows, the OfS has noted include substantive requirements. So if we can go on to the next slide, please, Kate. This just summarises for us the 5 sets of new requirements. The requirements relating to disclosure of information are already in effect. So those came into effect on the 1st of September last year. And the remaining provisions come into force on the 1st of August 25. I would say that in terms of content and actual subject matter, to my mind, there's not really anything new here that the sector hasn't been considering across both staff and students for quite some time. But of course, we do have a new regulatory bite because they are now set out as a regulatory requirement for institutions that are registered with the OfS. So a quick recap. We have, first of all, the requirements relating to policies and procedures. I think that subtitle is interesting because the conditions there actually talk about the single comprehensive source of information that registered universities need to have in place and what goes in that and the requirement to comply with what's in that. We lose the focus slightly on policies and procedures. That troubles me a bit because I think we have potentially lost the focus on having policies and procedures which are fit for purpose. That certainly was a focus of Universities UK when they were publishing their suite of documentation back in 2022 in relation to staff and student sexual misconduct. Then we have the requirements relating to intimate personal relationships between staff and students. Again, nothing really new to my mind here. It continues a long-standing sector debate, including the contributions that the 1752 group have made to that debate in relation to postgraduate students and early year academics. But what we have now is a protection for students from actual or potential conflicts of interest or abuse of power. Then we have the requirements relating to capacity and resources, so a regulatory obligation on registered providers to have in place capacity and resources necessary to facilitate compliance with the new condition, not just financial resources, but also, and I'm paraphrasing slightly, but the requirement to have a sufficient number of competent, adequately trained staff in place, particularly around carrying out investigations and decision making. I think given the overlap between the staff and student legal framework here, it's not an identical frameworks, but the overlap there, and also the interesting question around what parity of treatment and experience there should be for staff and students, there are some economies of scale there that I think universities may want to think about and harness, particularly given the current sector, the restraints on the sector financially. Then we have the requirements relating to freedom of speech, paraphrasing, but effectively what the requirements do is require universities to have regard to freedom of speech within the law, academic freedom, and tolerance for controversial views when they are dealing with the issues arising from sexual misconduct and harassment affecting students. Very interestingly, OfS puts that in the context of education and the educational environment, and the condition does provide for a rebuttable presumption that things that students are exposed to as part of their course, the higher education course, won't constitute harassment. And then finally, the requirements that are already in place, the requirements relating to restrictions on the disclosure of information as it affects students. Again, nothing really new here from what we saw in the pledge that many universities have signed up to. The pledge in relation to non-disclosure agreements, interestingly, covered students and staff. E610 only covers specifically students, but the guidance does encourage, the OfS and the guidance does encourage universities to think about other persons, including staff. So if we can just go on to the next slide, please, Kate, because of course the tricky bit is what all this means in practice. And from my student perspective, I think a key part of this is the definition of minimum content requirements, which is set out in the definitions section, which require universities to take steps which could, not will, could individually or in combination make a significant and credible difference in, as the slide says, protecting students from harassment and sexual misconduct, reducing the likelihood of harassment and sexual misconduct taking place, and effectively supporting students affected by harassment and sexual misconduct. I think that word protect is interesting in the context of the Office for Students. It's a word that the OfS is very keen on, the protection of students, but quite how it fits alongside, for example, a university's duty of care at common law, I think would benefit from some wider sector consideration. So in terms of what this then means in practice, just a reminder on the next slide, please, Kate, this just distills down what we've called here the do provisions that are set out in that definition of minimum content requirements. So those requirements in relation to reporting mechanisms in place, not just for students, interestingly, the condition expressly refers to reporting mechanisms for staff, students and others, the issues of information handling and use, informing students to ensure understanding of what goes into the single comprehensive source of information, what constitutes harassment and sexual misconduct, etc., issues around support, obligations and encouragement in relation to staff training, which Sian is going to pick up in a moment, I think. And then some key requirements around undertaking fair, lawful, credible investigations, decision-making, and of course that very thorny issue around what information can be disseminated, including around decisions and reasons. To my mind, that screen and E6 really shows that whilst the registration, new registration condition might not necessarily throw light on all of those things, it at least illuminates the areas of darkness, particularly around the issue of fair investigations, decision making, and information sharing. What it doesn't do, and we wouldn't necessarily expect a regulatory requirement to do this, is just give any more guidance or prescription in terms of what the underlying legal framework is. And that, I think, is a point, very important point to my mind, that I don't think a university is really going to make sense of E6 and comply with E6 without a firm understanding of that underlying and wider legal framework for both students and staff. That includes, for example, understanding obligations of a university under natural justice, the Equality Act, human rights, data protection, etc. That bit I think is missing here, but is part of a wider whole. And just some concluding remarks before I hand over to you, Sian. What we also don't have from Condition E6, which again, I don't think we would expect necessarily from a regulator's condition, is anything in relation to that institutional, cross-institutional approach across student, staff and others. The culture aspect, which certainly Universities UK has addressed in its changing the culture work, issues of institutional strategy, and also the importance of taking a trauma-informed approach across staff and students to investigations, decision-making, etc. So I see this condition as a part of a much wider and long-standing whole, and I think it's important to understand the different components in the whole. The 1752 group, interestingly, has described the new condition as a tool that student staff might want to use to push their universities to do more, in fact. So an important part of a wider and quite complex agenda. So on that note, I shall hand over to you, Sian.
Thank you, Sian. So I'm just wanted to mention that you can, as Kate said at the start, use the Q&A function if you've got any questions. We have had some that were sent in advance, so hopefully we'll have time to get to some of them. If you do have any as we're talking, then do pop those in the Q&A function, and we'll try and get to as many as we can. So as Sian said, I'm just going to touch on a few points from the staff angle. And as Sian mentioned, there are economies of scale and there is real benefit to achieving what OfS hopes in relation to the condition by taking a real whole university approach to the condition. There are three specific points covered on the slide that I wanted to mention this morning. And the first one is in relation to the definition of staff, and it's worth being conscious of this because the condition has a really quite wide definition of staff which might not correspond to your particular institution's definition, and this includes but isn't limited to contractors. So it covers individuals, whether they're self-employed, employed or workers. So it is quite a wide definition, so it's important to make sure that actually you are covering the obligations in relation to all of your relationships with particular individuals that may work on campus or engage with the university. The second point I wanted to touch on was about intimate personal relationships. And again, within the definition of staff, there is a narrower definition in respect of intimate personal relationships. And so the OfS has defined it as a relevant staff member for this purposes as a member of staff who has direct academic responsibilities or other direct professional responsibilities in relation to that student. And so that's more specific for this particular purpose, in contrast to the wider definition that you have for the whole of the condition. And more specifically, in relation to intimate personal relationships, the condition says that the comprehensive source of information, which Sian has mentioned earlier, must provide one or more steps which make a significant and credible difference, again, to protect students. And this is in relation to and from any actual or potential conflict of interest and or abuse of power. So that is what the restriction is in terms of protecting staff in the context of intimate personal relationships. And as part of the consultation, there was discussion around whether the condition would prescribe as to whether higher education institutions should ban or just discourage or prescribe that there's a disclosure of central record of intimate personal relationships. And the condition, the final condition, hasn't prescribed as to which approach that a higher education institution should take, but it does say that one or more steps could include a ban or a statement that disapproves or discourages intimate personal relationships. And the latter may contribute to compliance, but it's not saying that actually a statement disapproving and discouraging would be wholly sufficient to make the significant and credible difference which it is prescribing that you do need to make. So it is worth looking at the guidance. And I know from our discussions with various institutions that there are differing approaches across the sector, and some have taken a different an approach, and then that has changed. And there is particular circumstances that may dictate one approach over the other, but it is worth looking at the guidance around that to make sure that you're confident that it would comply with the expectations and the conditions in relation to intimate personal relationships. And the third point that I wanted to discuss was about training in the context of employees and staff, as I say, mentioning that it's the wider definition, so not just your employees, but also workers and others that may fall within the wider definition for E6. And the condition prescribes that it has to be appropriate and effective training. And so I've looked at this really from three different angles, and there's probably three layers. The first layer is for all staff within the definition, and this really can be described as an awareness training, so to cover the definitions of harassment and sexual misconduct, not in a 2D way, but actually in a practical way as to what may constitute harassment or sexual misconduct in particular contexts. And so it's unlikely that an off-the-shelf EDI or DEI training online that you get, that you may already subscribe to as your institution at an induction only is going to be sufficient for those purposes. It needs to be more of a workshop-based and interactive session to encourage that awareness on a practical level. And it also needs to be awareness of the not only the requirements of the condition, but also the freedom of speech principles, which is a theme throughout, which Sian has mentioned earlier. And the second layer is a more tailored approach, and the condition says that there needs to be a more detailed and focused training for the particular category of staff who are going to be receiving disclosures and also investigating and making decisions around sexual misconduct and harassment. And again, this needs to cover awareness of the requirements of the condition, so the first layer, and building on that with more detailed awareness about relevant policies and procedures, thinking about scenarios and case studies, and the fundamentals of decision making, particularly given the complexity when there may be difficulty in weighing up the evidence if it's one person's word against another person's word without any other witness evidence or documentary evidence which you may have in different circumstances. And then the third layer is for a particular category, again, of tailored training. And this is sessions and workshops for governing bodies and executive leadership teams, because ultimately they are responsible for the compliance with this condition. And so they need to be confident in exercising their responsibilities and having oversight of the compliance and scrutinising the operational compliance on the ground across the whole of the university. And again, there are specific things that they would need to consider beyond the other two layers and the categories of staff that I previously mentioned. And then just moving on to the next slide, Kate, the final point I wanted to mention was a separate piece of legislation, particularly for those of you who aren't employment lawyers or in your HR teams and necessarily applying it from a staff perspective. There's a new legislation that came into force in October 2024, and that's the Worker Protection Amendment of Equality Act 2010. And that is effectively brings in a general preventative and anticipatory duty to prevent sexual harassment. This is just specific to sexual harassment, so it's not all other kinds of harassment. A specific anticipatory duty to prevent sexual harassment and take reasonable steps to do so. And there is an associated guidance which the EHRC has issued in connection to that, and that outlines 8 reasonable steps, which is expected that employers, so this is beyond the sector, but applies to the sector as an employer, that actually the EHRC provides 8 steps, and I'll just mention a couple of these without going through them all. But one is that you are expected to have an anti-harassment policy, and that being a reasonable step to prevent sexual harassment. You're expected to engage in staff regularly, and that includes similarly to the training. That shouldn't be one-off. There should be regular review as to actually the steps that you're taking. Are they working? Do you need to adjust what steps you're taking in the same way that OfS is expecting in relation to E6? And also assessing risk, similarly to E6, and assessing risks in particular contexts. And so it might be taking into account particular risk factors. So there's a power imbalance between staff and students, for example. Is there a particular social context or social event which might increase the risk of sexual harassment occurring? Similarly, the risk of a field trip or the risk of a one-to-one tutor meeting is slightly higher than perhaps it would be in a wider lecture type context. And so it needs to be a really tailored approach to risk, but a lot of it is overlapping with the expectations and the prescriptions in the condition for E6. But it is worth it just being aware of this wider obligation that is applicable to the higher education institution as an employer that's been brought in by this Act in October, and having a look at the prescribed 8 reasonable steps that EHRC has outlined, because there is risk in terms of an uplift if a tribunal claim is brought. But again, this applies to staff rather than to students. But again, it's worth considering this as an overlay, rather than complicating and seeing it as something separately. It needs to be really integrated to what you're considering in terms of complying with your obligations under E6. So that's a real whistle-stop tour. I'll pass over to Kate, because I think I can see we've got some questions.
Yes, thank you both very much for that comprehensive run through. I suppose, as you were both talking, one observation of mine is that I wonder how much we're in danger of forgetting the other aspects of harassment and focusing on sexual misconduct, because that's obviously very difficult, and because of the focus on relationships, and so I just wonder. Anyway, that's just an observation. Lots of questions, and we're definitely not going to have time to get into all of them, because some of them are incredibly I'm not surprised, incredibly intelligent and detailed. One here that you might be able to address is that around the training, does it need to be workshop based? Our person asking the question observes that they thought that e-learning modules might be sufficient.
I think this is an interesting question, which picks up to, I was talking to a colleague yesterday about the OfS. The whole point of this is that and it's a condition rather than an expectation, which it was previously, is that they don't consider that there's been enough change. And so in theory, yes, you could probably have an e-learning module with a quiz. But part of this is the feedback, and actually, is the prevalence reducing? So is it having an impact? And therefore, thinking about a workshop is likely to have a greater impact. The more interactive training is, it generally has more of an impact. And the wider piece is the need to really change the culture, and that depends on what the prevalence issue is at your particular institution as to whether how big that change might be. And the whole point is to keep it under review. So if you start with the e-learning module, is that having the impact? Does that mean that actually our staff and our students are aware to the level that they need to be? And is that affecting the prevalence? And if so, well, great. And actually that's working. If it's not, then adjust it, and maybe we do need to have a bit of a workshop model, or actually do you just apply the workshop for those that need a greater detail when it's those that are involved in investigations and decisions, and you need to perhaps work through some case studies. I think the important bit is trying and making sure you're agile in terms of adjusting, responding to that. I don't know if you've got any other comments from a student perspective, Sian or Kate.
Yeah, I just pick up on your words, the word that you used there, Sian, about need. I think it's a need. I know the OfS has said it would expect training to be more than just the sort of sitting in front of a screen, the interaction point. But I think what a university really needs to do is to sit back and think about what is needed in each case. It goes back to your layers. And I personally would look at, particularly if we're in the context of, say, for example, those that make decisions or support students or deal with reports or investigate, is what is needed for those members of staff to be competent from a, sort of standard of the reasonably competent university, and also confident. And once you're in that space, it seems to me you want something more than just an e-module alone.
Thank you. And just quickly see if we can get another question in, which is, I suppose, about, again, comes back to the broad nature of the application of the condition, which is how it does the condition apply to all categories of students? So, undergrads, postgrads, distance learning, etc. And also, how does that interact with collaborative partners?
On the face of it, it does. It applies to all students, and indeed not just students who are registered. And if you read through the guidance, the theme that runs through the accompanying OfS guidance is that universities do need to think about the diversity of their students and particular needs in particular instances and categories, and that includes not just protected characteristics, but others as well. I think universities, in my experience, are very good at thinking about the diversity of students and working, for example, with their students and students' unions, etc., to do that. But there is a bit of a forensic approach that needs to be adopted to this, I think, and to really consider and identify all of those different cohorts, including part-time students who live in halls of residence, mature students, etc. I think how it applies in the collaborative provision space is difficult. It might be easier if you are looking at a sort of franchise subcontracting model with your partners. What I think is more potentially troublesome is that sort of validation arrangement where a university may be validating awards but never actually see these students, and they're not registered with students. So there's a piece of work, I think, for the sector to do, but also for individual institutions to do, because of course this is not a one-size-fits-all.
Thank you very much. And I'm just mindful of time there. I think we've come to the end. Thank you all for joining us. I hope it's been informative. There's lots of questions here, so there's clearly more discussion wanted in this space. And please do let us know if we can help you with any aspect of this, because as we've just seen, context is everything. There isn't any one-size-fits-all approach to this. So thank you all very much, and we will forward the recording to you.